Hi, my name is Kira, and I am here to deliver Raphael Burchard's talk about violence assessment and prevention. This is an introductory course to the subject and I intend to follow it up with further advanced material. Let's start. By the end of this course, you will have an understanding of the legal consequences of physical self-defense, understanding of the personal consequences of physical self-defense. You will have an insight into the origin and types of violence. You will be able to recognize stages of self-defense and apply theory to practice. Before we start, I like to introduce Raphael more to give you additional information about his experience and knowledge. Raphael started his martial arts adventure in 1990. It was some time ago. After 3 years of challenging training, he became an instructor. Raphael delivered training to all age groups and all grades. One of the areas of his specific interest was self-defense. He took part in numerous tournaments, both kata and free fight kumite. Raphael's last tournament was in 2008, where at the same time he graduated to 3rd dan in karate kyokushin and received a nomination for branch chief in Scotland. He was the founder of kendo and free running in Lublin, Poland. Raphael was not only restricted to kyokushin karate but during his active days studied other forms of martial arts to upgrade his understanding and knowledge about martial arts. After graduation from college, Raphael pursued a career in security. He completed 2 years of security and personal protection college where he received extended firearms training and began his work in various settings. Raphael worked as security personnel on numerous sites, concerts, public events, and nightclubs. Raphael started his security work when he was 18 years old, and he was exposed to several events and interventions. This exposure gave him a ground for the work that he is presenting now. During his self-development, Raphael came across 2 people who influenced his point of view greatly. Gavin the Becker, author of The Gift of Fear, and Rory Miller, author of Facing Violence. Raphael and I would like to thank them for the knowledge we gained from them. Raphael attended many self-defense and karate seminaries and courses both as an instructor and a student. Over the last 15 years, Raphael developed his self-defense system that incorporates both physical and non-violent interventions and approaches. Although the last few years he focused on non-violent self-defense, and this is the main part of this presentation, Raphael shared this system with his colleagues and friends. Today he wants to share this with you. Raphael's practical experience was further dependent on human behavior study. He finished his master's degree in sociology, advanced degrees in hypnotherapy and counseling. Raphael's area of interest and expertise is in recognizing abuse, including domestic abuse. He works with clients recovering from violence, and he assists them to develop skills to protect themselves and apply non-violent self-defense in practice. And now is the time to address the first 2 learning outcomes, the legal consideration and personal consequences of physical self-defense. Before we move on, I need to highlight that the following slides will refer to the law in Scotland. I strongly advise you to research what laws are in force in your country. A person may use such force as is reasonable in the circumstances in the prevention of crime, or in effecting or assisting in the lawful arrest of offenders or suspected offenders or of persons unlawfully at large. The key word here is reasonable. I am not an expert in the law, but this word is affected by several factors. The main factor is, what is reasonable for you might not be reasonable for others, and if you use force in self-defense, the judgment of, had you used reasonable force, will be completed by others, and it will be on you to prove that your use of force in the circumstances was reasonable. Let's look at the next slide. A man who is attacked or believes that he is about to be attacked may use such force as is both necessary and reasonable to defend himself. If that is what he does, then he acts lawfully. In the above statements, we can see highlighted words, is attacked or believes that he is, and both necessary and reasonable. The first one gives a burden of proving that someone attacked you. It sounds easy, right? In one-to-one situation, we have a word against word. If someone wants to attack you, we'll seek a quiet, secluded space, with no witnesses, or witnesses that will testify against you, so it is not clear anymore who and what. Proving that you were attacked is not as easy as we could think anymore. One of my clients, let's call her Lucy, was suffering ongoing domestic abuse. The perpetrator on regular basis used verbal abuse and leaned toward physical abuse. One evening, Lucy, after another incident of verbal abuse, Lucy noticed that the perpetrator is closing in, with the intent to attack her. She reacted instinctively, throwing an object she was holding in her hand. She missed him, but the police were called in. My client, who is a victim of domestic violence, was sentenced to an assault charge, and this will tie in with the next part, necessary and reasonable. Let's look at the following example. If you are lucky enough to put the other person down, problems will start to pile up. If you decide to leave on the street bleeding and unconscious person and he dies, well, you are in a deep, deep hole. If you on the other hand contact the police and ambulance, you are only slightly better off. You will still have to go to court to prove that your actions were legit. Was there anything else you could do? Was your use of force reasonable? Let's look at the next slide. If there has been an attack so that self-defense is reasonably necessary, it will be recognized that a person defending himself cannot weigh to a nicety the exact measure of his defensive action. If the jury thought that in a moment of unexpected anguish a person attacked had only done what he honestly and instinctively thought necessary, that would be the most potent evidence that only reasonable defensive action had been taken. These paragraphs demonstrate that there is recognition that a person could have difficulty recognizing the severity of the attack, and the use of force could be not proportionate, reasonable, or necessary. But, following the highlighted statement, if the jury thought, again the burden of persuading is redirected on you, and the decision is in the hands of the jury. This is like being in a casino. Your future is in the hands of a few people. If your oratory skills connected with the knowledge of the law are not the best, you might find yourself behind the bars for some time, unless you are fortunate to have excessive savings to cover the lawyer fee. In this case, you will suffer the financial consequences of your actions. Let's move on to the next page. Home Office statement said, the public should not intervene in any situations of any criminal activity. They may put themselves in danger, exacerbate the situation and ultimately be acting on the wrong side of the law. The above statement clearly instructs citizens not to get involved in any situation that could potentially escalate. Moreover, any actions that you could take have the potential to put you on the wrong side of the law. The underlying suggestion is to contact the appropriate authorities who have the legal grounds to act. If you are in the wrong place at the wrong time, you might witness a situation where people are involved in a fight, and trying to intervene you could be on the wrong side, or the attention of one or both sides might be redirected to you, and now you have a problem. Many moons ago Raphael got himself into a middle of a dispute. The male perpetrator was physically abusing a woman. It was a late evening in the middle of the summertime. Raphael reacted to this situation as he was trained at the time. To his surprise, the female started to defend the perpetrator, and he got himself into a middle of a conflict with both of them. Now he knows that the approach should be different. Report and use your mouth to de-escalate the situation. Now it is time to shortly summarize. Physical force is legal when a person is attacked or believes that he/she is, and the force is both necessary and reasonable, but only if the jury thought that a person had only done what he/she honestly and instinctively thought is necessary. Otherwise, you are acting on the wrong side of the law, so you should not put yourself into this position if you can avoid it. If you get involved in physical self-defense, it will be on you to prove in front of the jury that your actions were necessary and reasonable. This might cost you money, time, stress, job, depleted savings, broken relationships, and physical and mental damage. Physically recovering from encounters can take some time, often leaving scars on your body, and some psychological wounds might never heal. Thank you for your attention, and I'd like to invite you to attend the next part of this course, What is Violence? In the next part, we are going to analyze the different origins of violence and divide types of violence. To get the announcement, once the next part is available, please subscribe and select the notification option. My name is Kira, and I am Raphael Burchard's voice in the online world, and you have been watching Violence Assessment and Prevention Part 1. Thank you and see you next time.